Hello again, everybody, and welcome to session 3, the panel called the Digital Markets Act, Do the Proposals Work? This session will discuss the scope of the DMA and the criteria by which it qualifies gatekeepers. It will look at the impact the proposed rules will have on competition in Europe, on existing and emerging business models, and will look at the extent to which the European Commission, as the enforcement body, will be resourced to provide the advice and consultation, supervision, and ultimate implementation of the rules in the coming years, a whole issue of governance that we've been hearing a lot about already this morning. To discuss this for the next hour and a quarter or so, we have an excellent panel. I'm starting with Evelyn Gebhardt, a member of the European Parliament, Shadow Rapporteur for the DMA Act in the Internal Market Consumer Protection Committee at the European Parliament. Welcome, Evelyn, and thank you for being here. Guillaume Loriot, Director Markets and Cases 2, Information, Communication and Media at DG Competition at the European Commission. Welcome, Guillaume. Kiel Ander, who is Vice President for Corporate and Compliance Law at Apple. Welcome to you, Kyle. Richard Feasey, Senior Advisor at the think tank SER. Hi, Richard. And last but not least, as we always say on these occasions, Christophe Roy, who is Chairman of the Board of the Association of Commercial Television in Europe, ACT. I'm going to ask all of you to give some maybe introductory remarks about what you think are the most important aspects of the DMA from your perspective. And I think it's only appropriate that we start with Evelyn Gebhardt, a distinguished European parliamentarian of many years standing, if I may so, Evelyn, to invite you, first of all, to make your opening remarks. Over to you, Evelyn.
Thank you very much, Paul. Thank you very much to have the opportunity to have a consideration of what's happening today in this area. And I think that it is really very welcome that the European Commission made proposals on DMA and DSA, because it is really very important that we decide on common rules within the European Parliament, not to have at the end 27 different rules, but the same, and to have rules also. And I think it is really very, very important to ensure that we make it in a very well way. But one is very clear, I have to say, when the European Commission makes a proposal, we as parliamentarians says, yes, it's good, okay, that is a good thing, but we could make it a little bit better, and that is what we want to do, and that's in a common work with the European Commission and the Council, because it is really very important to make a very good things. And I think it is really important and necessary to make this DMA and to give good answers to the powers today the gatekeepers have, and there it is important to have in consideration a few points. I will not go on all points which are necessary to discuss on, because I don't have enough time for that. So first of all, I want to speak about what is a gatekeeper, and in the definitions the European Commission is making, I think we have to have a look on that very clearly, because I'm not sure that regarding this designation of gatekeepers, the definition of core platforms are really the good one with that cumulative way. And I'm not really sure that all really important gatekeepers are really within it, and we will have to have a look on that. And one of the problems I see, to give an example, is that I do not understand why, according to the user numbers, it is only on the core platform service and not on the use of the number across all core platform services, because it is used today, and we see it in everything, that platforms go from specializing on one service, as it was first with Apple's on phone and computers, towards more services. So Apple has now one bundle that includes iCloud, Apple Music, Apple TV services, and so on, and BitFit and whatever. And we have to ensure that we have in consideration this new way of considering of working of platforms that we see today. And that gives me the opportunity also to go to the second point, which I think is really very necessary to discuss on, is also to see in that way why I'm asking myself the question why the Commission did not include on-demand audiovisual media services in within, like Netflix, HBO, Hulu, or whatever. So maybe I know that Mr. Loriot is coming after me. Maybe he can answer that question and to give me here an introduction. The second point I want to raise is that one of the do's and don'ts which we have in Article 5 and 6. There, I have to say, I'm a little bit unlucky. I'm a little bit unlucky on the way how it is done, because I have the impression here we have past or current antitrust cases, which from which we know, and give an answer on this one. To have an overall answer is okay, but is it really future-proof to make that in this way? And would it not be preferable, and that is one of the questionings I have, I don't have an answer today on that, but questioning if it is not better to go to be future-proof, to go on reorganizing by stating principles and then example rules, and to have obligations which should be more precisely specified, an action or a prohibition according to positive rules to ensure effective enforcement. That is also one of the questionings I have to ensure that at the end we have really a very future-proof way to work. Another point which is in the discussion also in the European Parliament is that question on interoperability. Despite the fact that the proposed DMA provides for interoperability, this obligation is limited to ancillary services and does not apply to gatekeepers' core services. I am wondering why. Why is that as such? And gatekeepers should be obliged to enable interoperability, sorry for that word, difficult word, not only for ancillary services, but also for core platform services. And I think that we have to discuss too, because, for example, Facebook and competing social media networks or WhatsApp and other messaging services apps should be interoperable. I think it is really very important. And today, to make it really very clear, with that new rules that WhatsApp will have next time, many people, me too, are discussing, do I want to take longer this, or do I want to switch to another one, but how to take on board what I have made in WhatsApp? That is a big question, and where we don't have an answer today. And that is a way of having power about people that I think is not really acceptable. To be clear, there are some of the discussions we have. As I said at the beginning, I'm really happy that we have that proposal on the table, because there are many things which are very good within, but I think it is possible to make it better. And one thing, at least what I want to say, is that I'm a little bit worrying why not more the end users and the consumers are taken in account in the answers which are given in the whole of the text. And there, I think we will have to have a look from this side, because the side of businesses, of big platforms, is very well taken in consideration, but not that of consumers and end users. And I think that will be really very important to do, because unfair practices of big online platforms affect individuals, but also the society and democracy. And it is not only about the economic implications to consumers, but also about fundamental rights, individuals, society, democracy. And I think that is very important to take it a little bit more or much more in account than it was done in these texts we have today. So that is the first introduction from my side. I hope it was understandable. Thank you very much.
Thank you very much, Evelyn. That was extremely understandable and very comprehensive as well. And the running order is very propitious because many of your interventions were asking questions which effectively we can address. Now, to our next speaker, Guillaume Loriot of the European Commission. I'm sure you were taking lots of notes, Guillaume, about Evelyn's concerns. She said she was unhappy about a number of aspects, and you're now here to tell us if you can answer any of her, address any of her concerns. Over to you, Guillaume.
Well, thank you. Can you hear me?
Yeah.
Thank you. Well, indeed, I mean, I won't repeat what Gerhard has said earlier on in order to present the proposal, which is a legislative proposal and which is indeed now open for discussion with the Parliament and with the Council, so with the EU legislators. So I fully understand Mrs. Gebhardt, first reflections to say, well, I understand she agrees on the aims, but that there are many points to discuss and to clarify possibly. So I'll try to do that because I think it's more interesting for everyone listening in rather than having another presentation about the DMA. And I think Mrs. Gebhardt raised essentially, if I noted well, questions about the scope, the notion of gatekeeper, the do's and don'ts. What should be the aim of the obligations or the prohibitions put in that regulation. There's a specific issue about interoperability. What should we do? And then I think a very important question politically, but I think for us all is about are consumers empowered by this type of regulation? So let me try and start within these 5-7 minutes to start answering these issues. First, on the scope, I think what is very clear from the Commission's legislative proposal, and I understand that is something that normally is agreeable to the legislators, but obviously it will be a question for debate, is that the DMA proposal is an asymmetric regulation. So it is meant to address imbalances of trading conditions arising from the gatekeeper positions that some platforms have. And so it's an asymmetric regulation in the sense that it is aimed at improving fairness of trading relations and contestability of these markets by focusing on what we call gatekeepers. And that is a debate that is actually all over the world, within Europe, but outside Europe, on how to better address some conduct by gatekeepers. There are a series of tools. There's consumer protection, there's competition law, but they intervene in different ways. And here the idea is to make sure that as far as large platforms are concerned, there are specific rules of conduct that are imposed so that we maintain open and contestable markets, but beyond that, also a fairness of trading relations. Now, the question about how to designate these gatekeepers, I think there are specific rules and quantitative thresholds to make it as clear as possible. But these thresholds are presumptions, so there's flexibility upward, downward, in order either to maybe exclude some companies that would normally meet the quantitative thresholds, which are quite complex. Let's not go into the details, and vice versa, to include companies that may not meet the thresholds and should be included in the regulation. So I think the concern of Mrs. Gebhardt is that not all what she sees as gatekeepers would be included. Well, I think we have to discuss who would be included potentially, but there are flexibility tools, and the aim of the regulation remains to address only gatekeepers in order not to chill innovation and undermine innovation in these markets, and that is a very clear objective. And yet we believe that there's flexibility to make sure that we don't miss anyone or we don't over-regulate. That would be my first answer to the first point, but I guess we'll discuss again on that. The second point was about the do's and don'ts, and if I understand correctly, on the one hand, Mrs. Gebhardt said it should be future-proof. There should be principles, but on the other hand, it should be very precise in order to have legal certainty. And here, this is indeed a very complex issue, because the aim of the regulation is precisely to be complementary to other intervention tools, notably competition, which intervenes ex post on the basis of wide principles and very detailed market analysis based on effects. And here the idea is to have ex ante rules of conduct with no demonstration of effects at all, but like any standard regulation, giving the market players legal certainty on what is allowed and what is not allowed. And that calls for very specific provisions, because otherwise there's no legal certainty, there's no immediate solution. You cannot really prevent a conduct from happening, which is the main aim of the regulation in the first place. So I think there will be certainly a debate on how to draft these provisions even more precisely, potentially. I think that is open for debate and everyone would understand it. But at least the intention of the draft legislative proposal was to be as precise, predictable as possible, which is not an easy thing in markets that have very many differences. And I think everyone acknowledges that. So some rules might not be relevant for some gatekeepers because they are not active in some services, or because they are not a gatekeeper in some core platform services. Whereas they need to know what they should do or not when reading these rules, but also the whole market should know, because that's something that has been very visible in the various market consultations. There's an expectation in the market by business users that they know what platforms can do or not. And I think that is a very important issue politically, obviously, and that's where the regulation or the legislative proposal is adding value to what exists now, and that's the aim. We can go then later on what type of provisions, obligations are foreseen. Then, if I still have time, or 2 minutes, I think there are important points about, well, first on interoperability. Indeed, I mean, there are provisions on interoperability in the draft regulation, which are aimed at ensuring interoperability within the platform, so interoperability with ancillary services, because there's an issue to be debated that indeed interoperability between some services, and notably messenger services, so the WhatsApp of this world, is to some extent covered by the communication code, where there are provisions allowing to impose interoperability. So I think there's a debate there. But I think that was a trade-off that was foreseen in the proposal, to make sure that within the platforms, within the ecosystems, we improve and break more the network effects, so that there's a choice, for users, a real choice to have access to other ancillary services. Which leads me to the final topic raised by Mrs. Gebhardt, which is about what about consumers? Are they empowered by this draft legislative proposal? And to me, the answer is yes. I mean, obviously, the aim of the DMA, which is very much stated, is to improve the fairness of trading conditions and trading relations between gatekeepers and business users. And sometimes it goes well beyond competition. Frankly, it's something about really imbalance of bargaining power, and also improving contestability in a general way. But the beneficiaries of these rules of conduct that are foreseen will be business users, but also consumers. And specifically, many provisions are meant to empower consumers, either directly, if you think about portability of data, the need to opt in for any combination of personal data when using different services, when you think about making sure there is no technical restriction to switching, when you think about the capacity to download applications or other app stores. These are provisions that are directly empowering consumers. And obviously, there are other provisions that indirectly empower consumers, because they enhance the capacity of business users and developers to offer services to these consumers. So I hope that would be the first answer to Mrs. Gebhardt's points, but happy to discuss them.
Thank you very much, Guillaume. I see there's already a question in the chat addressed to you, but we'll hold off, otherwise we won't have enough time to listen maybe to the other panelists. Let's now turn to Kyle. Your company is obviously rather impacted by the DMA. Could you explain to us which parts of the DMA you think are good and you support, and where you think things could be improved, should we say? Kyle, over to you.
Thank you. I'm assuming you can all hear me.
Yeah.
First, let me just say it's an honor for me to participate in this discussion with such a distinguished group of panelists. We're certainly meeting at an interesting time, that's for sure. Over the past year, we've been reminded of the benefits that technology can bring, keeping us connected during the challenges of a global pandemic. It truly is hard to imagine what the past year would have been like without the technologies we have available to us today. Now, of course, at the same time, the last year has also reminded us once again that there are problems. And I appreciate that there's a real sincere concern amongst many that some companies have grown too powerful, too big, and that they got that way through bad practices or acquisitions. And furthermore, that they're using that position in harmful ways. Frankly, it's a concern I share. As I've looked at the development of the law over the last couple of years, frankly, competition law, it struggled to address companies that built large advertising businesses based on your data. And we've seen the emergence of some truly dominant platforms that control increasing amounts of personal data and use it in at least what I view as pretty scary ways. So I think we can all agree we should be working together to solve these concerns, which brings me to the DMA. There are provisions that make good sense. There are things that I agree with. However, it does not go far enough, at least in some ways, to solve the problems posed by data. And I'm very concerned that some of the provisions will actually do more harm than good, precisely because it doesn't address some of these tough questions. It relies on some general assumptions rather than case-specific determinations. And it divests regulators of the scrutiny and precision such complex and important matters deserve. Now, I acknowledge fully that there are going to be some situations where so-called gatekeepers' practices harm consumers, and that should be our focus, and changes are appropriate. But that won't always be the case, and at least the DMA as it's currently proposed runs the very real risk of requiring changes to practices to actually benefit consumers, support small businesses, and foster innovation, the very things the DMA is supposed to be striving towards. So let me offer two examples from where I sit. Take Article 6.1c, for example. It says that gatekeepers must allow installation of third-party software applications, regardless of where they're coming from. And I'm telling you, that would be flat out dangerous as applied to Apple. It's no surprise to anyone, we take a curated approach to the App Store. What I mean by that is we screen apps to make sure that they meet safety, privacy, security, and performance standards before they go on our shelves. We do that because we know that your iPhone is not just a phone. You use it to store photos of your kids, to communicate with your doctor, to manage your finances. And we don't want apps in the App Store or on the iPhone that would invade your privacy, put you in harm's way, or break your phone. And we work really hard to keep bad apps out of the App Store. But the DMA could be read as requiring us to let them in. Now, that would be unfathomable in the brick and mortar world. I mean, just take, for example, can you imagine a law that would require a grocery store to stock its shelves with food that the grocer was prohibited from first checking to make sure it was, at best, high quality, and at worst, not expired or a safety risk? This type of mandate applied in this situation directly undermines the European Commission's stated goal of creating safer digital spaces. Now, when a customer goes into a store today, she has choices from Apple, Samsung, Huawei, Motorola, Xiaomi, Oppo, Google, LG, and others. And we know, given iPhone has less than 25% share across Europe, that customers take advantage of those choices each and every day. If a customer wants our curated App Store approach, he can buy an iPhone. But if he wants a different approach without the protections Apple provides, then he can choose one of our competitors. We think our approach is better. We believe that privacy is a fundamental human right, and we build all of our products with that in mind. But at the end of the day, it's the customer's choice to go with us or with someone else. The DMA eliminates that choice, or at least puts that choice very much at risk, by imposing a ceiling on security and privacy. Personally, I think we should be raising the floor instead. Provisions like Article 6C and 6F, at least from where I sit, could do much more harm than good. Let me share a second example. Article 5C and Article 6K could force fundamental changes to the App Store model. These provisions might make sense in some context, but as applied to the App Store, these provisions would devalue investments and increase costs. It would force changes to a model that has worked incredibly well, and it would do so without any evidence that the change would benefit consumers. Today, Europeans have access to nearly 2 million apps in the App Store, and they can trust the App Store as a safe and trusted marketplace for customers to discover these apps. But it's more than that. It also provides a technology platform for developers to build, test, and launch their apps. I often refer to it as a gallery where artists can display their works, but also as a studio where they have the paint, canvases, and brushes to create them in the first place. Now, Apple could have charged developers for shelf space when we opened the App Store 12 years ago, but we didn't do that. Nor do we charge developers who sell physical goods or services via the App Store. Nor do we charge developers who earn money through advertising revenue. And nor do we charge developers who sell content outside an application, even if that content is used in the application. Apple makes all of this commission-free for developers, all of it. And as a result, about 85% of developers pay no commission to Apple whatsoever. The one time developers are required to pay Apple a commission is when they first acquire a customer in the App Store, and second, sell that customer a digital good or service that is used on the iPhone. If you're making money in the store by selling things used on the phone, we think it's only fair that you share in the costs that were incurred to create that opportunity. And by the way, that commission is almost always 15%. But the DMA could be interpreted as forcing Apple to an untenable choice. Make that free too, which would be making the entire store free, or change the model altogether, a model that has fostered previously unimaginable opportunity for businesses and customers, something we should be celebrating, not tearing down. All of which brings me back to my initial point. The DMA is born out of a valid recognition that there are problems that need to be addressed, but it presents a risk of making things worse, not better. By introducing more scrutiny and specificity, the DMA could be better positioned to meet its goals. It could be used to help customers. I agree fully with Mrs. Gephardt's observation that the DMA doesn't really address this important, possibly the most important constituency, and that really is customers. And we look forward to helping accomplish that goal. How do we best serve our customers going forward? Thanks, and I look forward to any questions.
Thank you very much, Kyle. I'm sure there'll be an interesting debate based on your remarks when we get to the discussion at the end of the first interventions by our panelists. I turn now to Richard. I think you have also, Richard, experienced in ex-ante regulation in other sectors. We heard Gerhard in his keynote talking about ex-ante regulation as applies to the transport sector, telecommunications, utilities, banking. So any insights you may have to share with us in those sectors as it could apply to DMA would also be very welcome. But without further ado, Richard, the floor is yours. Unmute, Richard, maybe. There you are.
Thank you, Paul. As it says, I'm an advisor to the Centre on Regulation in Europe. I'm also a member of the Competition and Markets Authority in the UK, but I should make it clear at the beginning, I'm not speaking on their behalf, but they've been doing some work in a similar area to the Commission on this, as I'm sure many of you will know. I wanted to start by saying I think the Commission should be commended for really moving very quickly in the last couple of years to putting a firm set of proposals for ex-ante regulation on the table for digital markets. A couple of years ago, the Commission had an expert group produce a report, which I thought was more sympathetic to continuing to use competition law to deal with some of the issues that have been identified than some reports from some other countries, including the UK. So I think the Commission has moved quickly to understanding and realizing that there are significant gaps that will not be adequately addressed by relying on competition law, and that therefore something else is needed. And to get to a clear set of proposals, so quickly, I think is good progress, and there is a need to move quickly for the reasons that we've already heard. So it's a good start. I wanted, with that said, to perhaps make 2 points about the proposals as they are at the moment. Both are really about the way in which the rules might be applied, rather than which firms they might apply to, where I broadly agree with the Commission. I think the Commission's idea with these rules, which some have described as being self-executing, is that the rules would be hard-coded, would be defined in the legislation. And then really the Commission's job is largely concerned with making sure they're enforced properly in taking action against platforms when they don't abide by the rules. That would be a very attractive model if it could be made to work, because you could enforce rules with a fairly small number of people. I think the Commission's proposal envisages 80 people to regulate, a very significant part of the European digital economy. Far fewer people than we see in regulators regulating much smaller parts of the economy in other sectors like banking or telecommunications, as you said, Paul. So in theory, the idea that you can do this with so few people, and all the work is really with the platforms to comply with the rules, is attractive. I can also understand why the Commission doesn't want to get into long, potentially time-consuming negotiations with the firms about what the rules are, for risk of them also being diluted as well as delayed in the process. So I understand why the Commission is taking the approach it is, I think, but I think it's unrealistic. And I think the Commission will not be able to avoid, in the end, a dialogue with the regulated firms to establish not only how to comply with the rules, but what the rules are. And it would be, as I say, good if that dialogue could be avoided, but I don't think it can. And if that's true, then really the question is, when do you have that dialogue between the regulator and the companies? And at the moment, I think my concern is that the DMA proposals anticipate that dialogue happens in relation to enforcement. So once a company has already been found to not be complying with the rules in the Commission's view, there then becomes a discussion about what actions and what measures the company needs to take in order to bring itself into compliance. And I think that's an unattractive point in the process to have that conversation, because at that point, relations normally between the regulator and the company are quite adversarial. The company is defensive, and things get difficult. In my view, it would be better to have a process in this legislation where there is a bit more of a conversation between the regulated companies and the Commission earlier in the process, before we get to the question of enforcement. Now, I know Article 6 says that companies can ask for guidance from the Commission if they want, but I don't see very strong incentives in the legislation at the moment to encourage companies to do that. They're expected to comply with the rules, even regardless of whether or not they start that conversation. They can be vulnerable to sanctions taken against them, whether or not they've asked for guidance. And I think, again, some thought could be given to providing stronger incentives for both companies and the Commission to engage in a constructive dialogue outside of the context of a situation where fines are being threatened or there's the possibility of other kinds of enforcement action being taken. But at that point in the process, in my experience, it's much more difficult to have a constructive dialogue about what action should be taken. My second point is that I am not sure there is enough clarity at the moment in the legislate and the regulation about what the objectives of the rules are. So they could be to prevent already very powerful gatekeepers from extending their power into new markets. So in competition terms, by leveraging the power they have in the core platforms into new markets where we might want to protect competition and allow others to compete. And there seems to me there are quite a lot of the rules, if you look at the list in Articles 5 and 6, which are concerned with that. But there's also possibly an objective of really trying to encourage competition in the core market, where one company at the moment, one firm at the moment, is really the gatekeeper and perhaps the only provider in that market at the moment. And that's a different sort of objective and might require different sorts of rules. And I don't think it's clear enough at the moment what the objectives are. There are a large list of rules, but they need to be focused, I think, and directed at trying to achieve specific objectives. And I think these distinctions need to be clearer. One way to do that, and I would say the way in which, for example, the CMA in the UK is thinking about this, is to distinguish between the rules that really are trying to get gatekeepers to behave as if they are in competitive markets, to treat their customers fairly, to do the things that in a competitive market firms would normally be expected to do. That could be sort of one set of rules, maybe an Article 5, and distinguish that from things that wouldn't necessarily happen in competitive markets, but the regulator might want to do, or the Commission might want to do for other reasons. So I have in mind particularly the data sharing obligations that are proposed in the DMA. It's not obvious in competitive markets that these platforms would voluntarily share their data with other companies. That doesn't always happen. This would be something that is a creation of regulation, a new set of relationships, and might require not only obligations on the gatekeepers themselves, but also on other companies who may be receiving the data and who may need to have obligations to keep it secure and so on, and to have certain standards. So this is a case where it's not just about regulating the core platform itself. It's about creating a whole series of arrangements that are intended to promote competition and develop a new market that might affect a whole range of firms. And that's a quite different sort of regulation to the first type. So those are the two things I think that we might want to think about a bit more as we debate the DMA going forward.
Thank you very much, Richard, for that very comprehensive also tour d'horizon of what needs to be addressed potentially in the regulation. Our final speaker is Christophe. Christophe, over to you, sir.
Thank you very much. Good afternoon, everyone. Very happy to be part of this conference. I'm working for Canal+ Group, but I will be, as you said, I will be intervening in my capacity of chairman of the Association of Commercial TV in Europe, ACT, this afternoon. So let me just tell you a few words on ACT. ACT represents 29 of Europe's leading commercial broadcasters, representing the majority of television channels and VOD services available in the EU. ACT members finance, produce, promote, and distribute content and services benefiting millions of Europeans across all platforms. Now, to ensure the sustainable future of the broadcasting sector and be able to continue to invest in content to the benefit of all viewers and also to the benefit of media pluralism in Europe, a fair and contestable digital market is crucial. And this is why our first reaction to the DMA, and the first thing I want to say is that ACT welcomes the DMA regulation. This proposal is a recognition, as someone else said, by the way, it's not only at the European level, but more globally, that there is this recognition that there are systemic problems that need to be addressed, and that for innovation to thrive and access to digital audiences must be fair. To this end, we think that the DMA holds tremendous prospects and value. We welcome all the more this regulation, since we've been asking for a level playing field for many years, as you know, and in all recent reforms, in the copyright, in AVMS, in all the reforms. The DMA can make a difference, a significant difference in addressing concerns regarding the detrimental impact of certain behaviors of large online platforms acting in a capacity of gatekeepers. There is clearly a momentum to adopt this regulation and to talk about this regulation. The COVID crisis has only reinforced and emphasized the need for an ambitious and speedy reform. The gatekeepers are the big winners, we know, of this crisis. Just one figure to illustrate that: the total revenue of GAFA in the last semester, after 2 lockdowns, amounts to 228 billion euros. Quite a big figure. So there is no doubt that this regulation meets an economic objective, but the challenges posed by the DMA, we think, as far as the audiovisual industry is concerned at least, go way beyond purely economic considerations. Ensuring a fair competition framework for European content players, which are mainly local players, is also a question of guaranteeing the production of rich and diverse European content in the long term. So behind the DMA is also the objective of preserving the European cultural sovereignty. And some of my colleagues were asking where the consumer is in this regulation. I think the consumer is here, not only here, but it's also here in preserving the European cultural sovereignty. So you understand we are in line with the DMA's intention, and our general reaction is a positive one. But of course, we would still like to draw attention on a few points of vigilance we already spotted in our analysis of the text. First, regarding the definition of gatekeepers, it is necessary to target the right entities, the ones that play a role of gatekeeper, and not more than that. I mean, even if you are a big player, it doesn't mean that you have to be regulated in the DMA. The object of the DMA is to regulate the gatekeepers. And of course, to avoid any new obligations for players that are already heavily regulated, like broadcasters. But in the same time, we would caution on the tricky procedure to identify companies offering core platform services, which could in some cases end in helping some players to escape from the regulation due to the number of criteria to meet for qualifying as gatekeepers. Furthermore, regarding the definition of gatekeepers, we all have also serious doubt about the effectiveness of the process. Indeed, the Article 3 establishes a presumption based on quantitative criteria, but we understand that the possibility for the gatekeepers to contest the status of gatekeeper could unduly result to a suspensive effect on the implementation of the obligations. In these circumstances, how the presumption could have a meaning and useful effect. More generally, we are concerned about the delay of implementation of the DMA. If we add up all the time periods provided in the DMA, the 6 months for the entry into force, and then the 3 months for the notification by the gatekeepers, the 6 months for a market investigation for designated gatekeepers, and again, the 6 months for complying to the obligations, the regulation may not be fully applicable before 2 years or even more after its adoption. This is totally contradictory with the urgency to enforce the DMA, recently reaffirmed again by Vice President Vestager before the Parliament. Always with this urgency in mind, we think that it will be necessary to define more clearly the articulation between Article 5 and 6 and the obligations in Article 5 and 6, and the conditions under which the obligations of Article 6 will have to be further specified. This articulation should be refined all the more than some of the obligations which are presently in Article 6 of the DMA relate to practices that have long been identified for seriously damaging competition. This was said also by some of my colleagues. We're not starting from scratch. We have many competition cases and investigations related to gatekeepers. We also have an interesting piece of legislation with the Platform to Business Regulation, which has set already very valuable principles, but unfortunately, these principles are not respected so far. For example, we welcome, let me just give you a few examples of what is very interesting in this regulation. We welcome the obligations on ranking, ensuring that gatekeepers apply fair and non-discriminatory conditions to offer third-party services and refrain from self-preferencing their own services. Given the harm produced by such practices, and as I said before, it has been previously condemned by the EC in the Google Shopping case, we believe that such an obligation should apply without any delay. We also welcome the prohibition for gatekeepers to use non-public business users' data to favor them in competing with their business users. And this problematic too has been under the radar of the national and European regulators for a while. So do we need any further, any more intervention of regulator and regulatory dialogue before prohibiting such practices? We believe no. Finally, it's important to stress that the DMA has to be future-proof by ensuring that all case studies, that all the unfair practices we experience as content service providers find an answer in the text. In that regard, we have found already some gaps. We can mention, for example, the absence of obligations for tackling abusive bundling and tying strategies deployed by digital gatekeepers. We also consider that the DMA is not precise enough in regards to algorithmic transparency. The Platform to Business, again, a regulation adopted last year, represented a first step in this direction by setting obligations for clearer terms and conditions of the main parameters determining ranking. But we know that these rules have not resulted in a change of behaviors from gatekeepers because of a lack of deterrent sanctions. So this is, I mean, the DMA is a real opportunity to go further in terms of algorithmic transparency. And just my last words will be on the enforcement part of the regulation. There cannot be a regulation, an efficient regulation, without enforcement measures and effective enforcement measures. Again, the illustration is a P2B regulation. So we will be very careful that in Chapter 5 of this regulation, the Commission is given the targeted powers and the right powers to address the gatekeepers and only the gatekeepers, and also that the Commission gets all the support that it can get from national authorities and from private enforcement. And in this regard, the DMA has can certainly be improved. Thank you very much for your attention.
Thank you very much, Christophe. We're going to try now grab some time for a panel-wide discussion. I think there's a broad theme here, with the obvious exception of Guillaume, that everybody else says we broadly support the DMA, but as Evelyn said, but. There's always a but. Before I go straight to questions, could be a shame to run out of time without addressing the questions in the chat. I would like to ask Evelyn quickly. I mean, Guillaume very gallantly used his speaking time to address the questions you raised in your intervention. So having listened to Guillaume now, are you happy with what he was saying? Does he answer the questions you were posing? Evelyn?
Not really, not really, and we will have to discuss it further. It is very clear because I think really that on these questionings I had, we have to discuss it and to see what is happening. In the definition in the scope, the definition of the scope, I already not really convinced that the European Commission did make here the right way, and I'm still convinced that we have to be more future-proof in the text, in all, and in Article 5 and 6 that are these the core points of the proposal of the regulation. That's very clear, and there we have to be really very careful what we do. And so I can answer the one question that is given by. I don't see the name.
I'll come to that in a moment. Yeah.
Yeah. Okay. So, we need more future-proofness, and we have to ensure also that we make work in how it's in English, as soon as possible. That is clear for me. We have to address these points very soon, but in the same time, it has not to be on the cost of the quality of the text at the end. Yeah, and that is something we have to say very clearly. I will not hurry up only to have a text at the end very soon, if at the end the text is not a good one. So we have to be careful on that, and we will see. We have many discussions to do on these points.
Well, thank you. Well, I'm sure you'll carry on the conversation with the Commission inside the IMCO committee in true democratic fashion. You'll have seen, Guillaume, let's open the discussion in the chat, a question addressed to you, but I suspect other people on the panel may want to answer as well, so please feel free to jump in as well. But let me first pose the question from Alexis Barafka, Head of Digital and Competitiveness of the Independent Retail Europe organization. He asked the question specifically to Guillaume. The DMA incorporates a set of investigative powers for the Commission copy-pasted from competition law. However, it does not refer to the procedural safeguards applicable under competition law and case law. For example, on-site inspections under competition law can be carried out if there are reasonable grounds to suspect an infringement, something that is not mentioned in the DMA. Can you elaborate, asks Alexis. Guillaume.
Well, my answer on that would be very, very brief, because I mean, I think maybe that is a topic for discussion, but at least the intention, which is clearly stated in the DMA, is to make sure that the rights to good administration, the rights of defense of the undertakings concerned, and the right to access to file, to be heard, are fully protected. Then there is a right to conduct on-site inspections at the premises of the undertakings in the context of market investigations and non-compliance proceedings and so on. I'm not sure it includes an announced inspection, so maybe that's something to check and double check. But I think here it's a very technical issue, but at least it's obvious that the rights of defense and the rights to be heard at different stages of these proceedings will be complied with. And it goes without saying. I think the principles of law in the EU are those of applied by the ECJ, the Court of Human Rights, and so on. So that goes on. If we need to improve the way in which we can enforce and inspect, so be it. I think that's a question for debate.
Okay, thank you. Anybody else want to come in? Richard? No, wearing your CMA hat? No. Okay, fine. Next question is from Kay Jabelli, who's a counsel with the CCIA, the Computer and Communications Industry Association. The question is as follows. With the ex-ante rules of conduct, there is still ex-post enforcement after a violation has occurred. Does this really create a framework to prevent future harms? Asks Kay. Anybody want to address that question? Yes, Richard. Unmute, please. There you are.
So I think this goes back a little bit to what I was trying to say in my remarks. I think it is simplistic to think that you can write a rule and then have a set of sanctions, and that with those two things you will get compliance and you will get well-functioning competitive markets. I think the world is more complex than that. For one thing, the evidence is that even sanctions and large fines, when it comes to very large digital gatekeepers, don't necessarily change behavior or deter conduct. And secondly, compliance is never, in my experience, a sort of simple black and white question. It's ambiguous, and we should not be naive. We should expect firms to test the boundaries of what is and is not acceptable, and that will require a sort of conversation between the firms and the Commission, in my view. And my point is, I think it's better to have that conversation earlier in the process than rely upon the enforcement process to do all of that work, if you like, in clarifying what is and is not acceptable. Because I don't think it's going to be possible to avoid that conversation. And otherwise, the Commission will spend all its time pursuing enforcement actions all over the place in order to get these rules to stick, in my view.
And Guillaume, you want to respond to that?
Yeah, maybe. I mean, that's I think the points that Mr. Fizzi has put forward, they are meaningful points, but indeed we're in a different logic. I think the point of starting a conversation and having an outcome in a very short deadline without knowing the rule in the first place, I think it's a bit of an illusion. So I think if you want to have added value with legislation compared to what competition enforcement is about, for example, which is based on wide principles, but based on very specific assessment of the likely effects, and I feel very comfortable with that. It's our job to demonstrate with evidence the anti-competitive impact in each and every case, but it doesn't have the systemic ex-ante approach that now the legislator and the market wants, to have clear rules and making these trade-offs. So there needs to be, in legislation, some clear rules on the basis of which the enforcers can have a dialogue, and that is foreseen in the regulation with those concerns and the gatekeepers concerned, to make sure that these rules are properly implemented. That's the spirit. And let's not forget that's a regulation. So if there are clear and specific rules, I think as Mrs. Gebhardt is looking for, they will be self-executing as well to some extent, so they can be invoked in front of national courts if there is a violation of these rules. What we need to know now, I mean, in terms of the added value of any legislation, is whether we set out clear and specific rules, taking into account, the various issues. That's not an easy task. Or, we postpone to a kind of ex-post implementation dialogue. But then one might question the added value of any legislation. I think it's meant to be complementary to other tools, ex-post tools like competition enforcement. I think that's the spirit of the proposal at the moment. And I understand there are different, I think Mr. Roy is waiting for urgency. I mean, that's a call, is waiting for speedy implementation. The market is calling for clear rules and predictable rules for everyone involved, not only the gatekeepers. So I think this is this conundrum that everyone is trying to sort out. And that's why this debate is very important indeed.
Okay. If no other interventions from the panel, another question from the audience, which touches on a point actually that Gerhard made in his keynote when he talked about the EU being ahead of the game here, ahead of the rest of the world rather, and an opportunity for the EU to help set the standards. The question is from Lindsay Partner, who's a partner with Deloitte UK, as follows: what can be expected in terms of convergence and divergence with rules governing these issues around the world? Taking the concrete example of the UK establishing its own digital market unit, how can it be ensured that the rules are in line with what other regions of the world are doing in that area to avoid global fragmentation whilst respecting European values? Interesting question. Who would like to respond to that? Yes, go ahead, Kyle.
No, I think it's a very good question. I think it's, I think there's a very real danger of fragmentation. I think you've already seen, even within Europe, some divergence between this proposal and things that we've seen in Germany with their competition law amendments. And if you broaden it globally, I think you're seeing a very different approach here in the United States. I think those of you who have seen Senator Klobuchar's proposal. It's very focused on making some amendments to competition law, kind of in line with what we saw in Germany. So I think there is this risk of divergence within Europe and outside of Europe with some of the proposals that we see on the table. So I'm not as convinced that you'll see kind of a common standard emerging, I think there's a very real risk of different standards and a fragmenting of markets, where you'll have a European market, American market, an Asian market that are subject to very different rules.
Thank you. Christophe.
Yeah, no, I'm not sure I'm the right person to answer that, but what I just want to say is that the risk of fragmentation would be even worse if the Commission was not doing anything, and if the Commission was not proposing this the DMA regulation. So, I mean, the risks exist, but the best answer to that is to have a European text applicable as soon as possible. And with the rest of the world, I mean, there will be a dialogue with the US, hopefully a better dialogue than in the past, and we'll see if we can also I mean, show, I don't know if it's show the way, because they will do it their own way, but I think that there can be interesting things also stemming from this dialogue between the US and the EU. So for me, the risk of fragmentation is much worse without the DMA.
Richard, would you like to address the specific about the UK? I mean, it's not the other side of the world; it's on Europe's back door, as it were. Is there a danger there?
Well, I mean, what I would say is I actually have been. I have been struck by how similar at least the analysis of what the problems we're trying to solve are across the world. Clearly, I think different authorities are focusing on different aspects. There's been quite a lot of debate in Australia about relations with publishers in particular. But actually, I think my sense is quite a lot of commonality on what the objectives are. I think we just have to expect that different organizations in different countries and different regions will take different approaches to that to some degree, partly reflecting their broader legal differences. It will be desirable for there to be coordination as far as possible to sort of reduce unnecessary divergences, it seems to me. But I don't think, it's not realistic, I think, to expect that there will be a single global approach here. And I don't think we should wait until we arrive at that point before people in different areas move forward in this area. No doubt there will be some issues and some tensions that come from that, which we will need to iron out as we learn and as we progress. So I'm not so concerned about this. As I think if people were trying to pursue fundamentally different objectives, then that would be a recipe for real concern. But I don't see that at the moment.
Okay, thank you, Richard. Guillaume, you want to come in?
Yeah, just 2 points. The first point on fragmentation, where there's a consensus that fragmentation is not good in itself, and the primary aim of the DMA is precisely to avoid fragmentation within the single market in the first place. So that's the aim, to harmonize rules to the maximum extent. And as many of these regulations, then there are other tools, and we have to make sure they interact correctly. But then obviously, if there was a global consensus on some of the rules, that would be even better. But I'm not sure, indeed, that that will wait until then. But there is, I think, a growing consensus, at least on the issues. And I think Mr. Fizzi is right. I mean, when you look at the UK, the CMA proposal in terms of objectives, I mean, the objectives are widely similar, except that in the EU, there is this additional objective of harmonizing the rules, having a single market in the first place. The second point I want to make is that look at competition enforcement. I mean, some years ago, the Commission and some NCAs were really the first ones to challenge new practices in the digital world under competition rules. That was very controversial at the time, and now it's kind of, it was evident. We're still in court to defend these cases, by the way. So we were, I think we were ahead, and there wasn't yet a consensus maybe across the Atlantic, where we see now that, the US and antitrust authorities are also acting in some cases with exactly the same issues. So I think it's always good to keep that in mind, that we can't wait and abstain. We need to discuss these issues, to try to legislate as efficiently as possible, not to over-regulate, but not to address these issues would really be a failure, and we need to go ahead and discuss that.
Evelyn, you want to come in? I'll ask you, Evelyn, to be quite brief, because I want to also ask you the question in a minute from the chat. So.
Yes, but I wanted to clarify it also very clearly, because I think the point is we cannot wait that the whole of the world is making a common rule in that, and we have other aspects where we did good work with the data protection to show it was the same discussion. Can we do that first and whatever? Today we have it, and other parts of the world are doing now the same as we did, and we have our European values that we want also to ensure, and to do so we have to give an answer today and not to wait too long on that.
Thank you very much, Evelyn. We have only 5 minutes left, so I'm going to use the opportunity of the last question from the audience addressed to Evelyn, but ask all of you to think about answering it in your own way as well, because it touches basically on governance, and it's une question assez chargée, I think you would agree, Evelyn. So it's addressed to you, but the panel will be invited as in terms of closing remarks to react as well as you see fit. The question from Alexis Varavka, very diligent person in the audience. The main added value of the DMA lies in the list of obligations under Articles 5 and 6. The Commission proposes to have the power under delegated act to modify these obligations, which may radically alter the balance of the DMA without the full scrutiny of the co-legislators, European Parliament. Shouldn't this power be subject to the ordinary legislative procedure with a proper democratic debate? You can go first, Evelyn, and then the rest of the panel.
I have to say I have to laugh, because I have to be now very undiplomatic and to say to you very clearly, the first time I read the text, that was my first impression. That is the text. The objective of this text is from the European Commission to give herself many powers. Yes, this was my first impression, and that will be clearly a discussion we will have in our Parliament, because but the European Commission knows that we want that the co-decision procedures are ensured in the core parts of legislation, and we will have to discuss this very clearly, because we want to have a good work, and we want to have also that what we need in a democracy, a discussion also in publicly way, what are the answers we are giving at the end, that is ensured. That is very important, and that is one of the main points we will have a discussion with the European Commission, that I know, but we will have it because we need it. And what we want really as a European Parliament, for me also as a representative of the European Parliament, is to have a good work at the end, to ensure that end users, customers, consumers are ensured to have all the possibilities of choice they want to have, and that there are not some people or some organizations in the world organizing the world as they want to have it, even if it's a good way, even if it's a good thing. I don't want it because it is things of society to decide by themselves what they want and what they don't want, and that is what we have to ensure, and what is given in this part of the work we have to do with the DMA.
Thank you, Evelyn. Guillaume, you may want to push back on this interpretation of the delegated powers.
No, I think the question illustrates very well the debate here about how to reconcile a democratic process that sets the rules, and that's for the legislator to set these rules. We agree, it's that's the aim. So how to have specific rules that are clear enough for the enforcer to act upon them. On the other hand, I think everyone is asking for making something that is future-proof, so that is not set in stone and you can adapt. So how do you do that efficiently? And that's all about the relationship between timing, speed versus managing complexity of these markets. Now, on the very specific, I'm not trying to escape the question. I think the point is in the regulation Article 10. I guess it will be a subject to debate. But what the provision is intending to do is to make sure that if the Commission can detect a practice that is, similar to the one that is listed in Article 5 and 6, but through another way, unfair in the same way, then they can adapt. But it's not extending the scope or whatever. I think that is very clear that it's for the legislator to extend the scope of a legislation or to reduce it. So I think the intention is, one, to make sure that it's flexible enough, future-proof enough, without obviously affecting the competence of the legislator. Now, I guess that will be a point of debate on how to draft this type of provision, but I think it's a very good illustration of the complexities of this exercise.
Thank you, Guillaume. Do you want to make a brief final comment, Kyle? Very brief, please.
Sure, very brief. So just to echo a couple of things, I think on the point around kind of this omnibus provision to create new rules and regulations, I think it underscores the need to kind of have some alignment around general principles. And I think, as Mrs. Gebhardt and others have mentioned on this call, I think that's missing to some extent. And I think it would be useful to kind of really focus in on what are we trying to accomplish and what are those principles that we want to guide us in the future. Because I do think many of the provisions are grounded in past antitrust cases against specific companies. And so I think it'd be very useful for all of us to kind of get some alignment around what those principles are going forward and how they may inform new rules.
Thank you, Carl. Brief final comment, Richard? Unmute, please.
Sorry, I think elected legislators should set the framework within which the Commission include, whether you call those principles or rules. I think those should be in the legislation. I want the Commission, though, to have a bit more room and flexibility than it has at the moment to engage then in a conversation with the regulated firms, and I want the Commission to have the resources to enable it to not fear those conversations, and I don't think AT staff is enough to do that.
Thank you, Richard. A brief final word from you, Christophe.
Yeah, very quick. I've heard many times that maybe the consumers were not at the heart of the regulation or should be more present in the regulation for us. I mean, we consider that the consumer welfare and consumer benefits is really the only objective of the DMA, and it's already shown in the DMA proposal. I mean, we are not saying that the big gatekeepers are not providing valuable and very needed services to the European citizens. Of course they are, and we welcome that. But at the end of the day, we want choice for the consumer, and for the consumer to have the capacity to choose. And as far as we're concerned, we're talking about content, to choose also rich and diversified content. We need competition on the market, and we need the local players and the European players to be able to continue to survive and to have a sustainable model. And for this, we absolutely need the DMA, and I think that there is a common understanding on that. So we are very happy about this regulation, and of course we'll try to make it as even better than it is today.
Thank you very much. Well, I think you'll all agree this has been a tremendous discussion. I'd like to thank the panel. I'm very cognizant of how busy you all are, so the fact you've made time today, I'm extremely grateful for that. Thank you in the audience for watching and listening. Thank you for your questions, and please stay tuned for our final panel coming up anytime soon. And again, final thanks to the panel. Thank you very much, all of you. Have a good fin de journée.
Thank you. Bye-bye. Au revoir.
Bye-bye. Au revoir.
Bye-bye.
Bye.
Bye-bye.